Good afternoon, everyone, and welcome to Eckstein Hall. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to introduce this year's Boden Lecture. Let me begin by recalling the individual in whose memory this lecture stands, the late Robert F. Boden, a Marquette lawyer from our class of 1952, a lawyer in Milwaukee, a Marquette law professor, and dean of this law school for some 19 years. As that brief list perhaps intimates, Dean Boden was an exemplar. This was so not only for our students and his faculty colleagues, but also for the profession more generally. Often during my own travels and work on behalf of the law school, I come upon lawyers in this community, both Marquette lawyers and others, who want to recall Dean Boden and his service and dedication to the legal profession and its best ideals. How right then that a decade or so after his death in 1984, various of those who knew him, including faculty and alumni, created the Boden Lecture in his memory. It enables those of us with a less direct connection to feel ourselves also part of Dean Boden's legacy. This annual lecture brings us together as a law school and intellectual community with a distinguished academic, someone from whom we can learn. And this afternoon we can learn much from Howard Shelanski, who will deliver this year's Boden Lecture. Mr. Shelanski is a professor of law at Georgetown University. He previously held the same position at the University of California, Berkeley, the place from which, some years before, he received both his law degree and a PhD in economics. Mr. Shelanski's scholarship is focused on antitrust and regulation, and he knows whereof he speaks. For in addition to his dual degree background, Mr. Shelanski has been an active practicing lawyer and, especially, a high-ranking official within the federal government. His positions have included service as a senior economist for the President's Council of Economic Advisors in the late 1990s, as chief economist of the Federal Communications Commission, and more recently yet, as director of the Federal Trade Commission's Bureau of Economics. Indeed, Mr. Shelanski is currently on leave from the Georgetown faculty while he serves as the administrator of the Office of Information and Regulatory Affairs in the White House's Office of Management and Budget, a position to which the Senate confirmed him as President Obama's appointee in 2013. His background also includes service as a law clerk to the late Justice Antonin Scalia. For the title of his Boden Lecture today, Mr. Shelanski has selected Sound Policy in the Balance, the Uncertain Future of the Regulatory State. Please join me in welcoming Howard Shelanski.
Thanks, Joe. Thank you very much. It's a great honor to be here. There's always a very daunting moment when one comes to the lectern and one realizes I have to be the person that was just introduced. I want to thank Dean Kearney for his generous introduction and to say that it's a great honor to be here speaking in this series named for Dean Boden. I want to talk today about the current state of the regulatory state in the United States, some challenges that those engaged in the process and substance of regulation currently face, and some suggestions for how we might influence in a positive way the future of regulation and the way the public debates and thinks about regulation going forward. To give you a sense of why I chose this topic and why I came to believe that there was a problem worth thinking about here, let me say a word about my current position and what I currently do, because that really was the motivation for my thoughts that I'm going to bring to you this evening. The Office of Information and Regulatory Affairs is an interesting office. What the office does, among several other functions, is review executive branch regulations before the agency that has promulgated those rules can publish them in the Federal Register and make them effective. It is an office that was created in 1980, early in the Reagan administration, for the purpose of putting in place an additional check, an additional layer of review on regulation, that major regulations that the government might issue. And the thinking that led people to believe that such a check was needed was not just, as many people would think, the Reagan Revolution that had a somewhat skeptical view of regulation embedded in it, but actually goes back to the previous administration, to the Carter administration, where a number of senior officials in that administration had come to believe that there were areas of federal regulation that needed some additional filtering and layers of thinking before they were promulgated. And the late economist Alfred Kahn, in his service in the Carter administration as administrator of the Civil Aeronautics Board, was one of the people who prompted that way of thinking within the Carter administration. So there was actually a handoff from a small office that was informal in the Carter administration to the Reagan administration, which then created this office much more formally. The office has since been enshrined in statute in the not terribly jazzy Paperwork Reduction Act as a statutory office within OMB. We do, incidentally, review all federal information collections, so we are involved in the paperwork reduction effort. But I think the office has come best to be known for its review of executive branch regulations. So what do we do when we review a rule? It's worth going through this for a moment because it will give you a sense of the way I have come to see the regulatory process, and therefore the contrasts that I see between the regulatory process as it is done internally and the way it is often discussed or viewed externally. When a rule comes to my office for review, and I might add, we do not review all federal regulations. In any given year, the federal government produces something like 3,500 regulations, many of which are very technical, very minor, really necessary administrative regulations to keep the government functioning or to keep various small things moving forward. We don't look at those rules. We look at what are defined under a series of executive orders and statutes that govern my office at significant rules. And there are a number of reasons a rule could be significant. It could be significant because it has a significant economic effect. And that is defined as having an economic impact on the economy of $100 million a year or more. When you think of an economy the size of the United States, that's actually a fairly low threshold. So if a rule is going to have that effect, we are required to pull it in and review it. A rule might be significant because it implicates a novel legal issue. And very often after a judicial decision out of a court, there will be regulations that line things up with that legal decision. And people will want to have scrutiny of whether or not the rule adequately puts those new legal positions in place. A rule could be significant, quite frankly, because the president cares about it. If the rule is one that implicates a key agenda of the president or the administration, we'll pull it in for review. And when I tell you about our review process, you'll understand why that's a good reason to call a rule significant. And finally, another very important reason for a rule, even a rule that some might see as deep in the weeds and quite technical, to be significant, is that two different parts of the government may have different views of that rule. There may be a rule that one part of the government wants to issue that is in conflict with another department's rule, or that may go into some turf that the other department was about to occupy, even if in the same way. So there will be a desire to have the different parts of the government coordinate on that particular area of regulation, and if we have some sense of that, we'll call that rule as well in for review. So what happens when we call a rule in for review? We have a variety of very specific things that we do. The first thing is we circulate the rule around the federal government to interested components. So if there is a rule by the Department of Agriculture that is going to have an impact on, say, the workforce in a certain area of agriculture, a poultry processing rule or a pesticide application rule that affects workers, the Department of Labor is going to want to have something to say about that. The Environmental Protection Agency might want to have something to say about that. We'll circulate the rule to those relevant agencies so that they can comment on it. But we also look at rules ourselves, and my office has a permanent staff of between 45 and 50 people trained in various disciplines. Very few lawyers, I might add, and most of the lawyers I have in the office, which are only a handful, are sort of incidentally lawyers. They also have other degrees that they're actually more actively using in the work that we do. So I have chemical engineers, I have toxicologists, I have economists, I have a lot of people with masters in public policy who are well trained in just a variety of good analytic methods. And I have statisticians, just to give you an example of the range of folks that I have in the office. And we take the rule and we review it for a number of very specific criteria. One criterion is the quality of the evidence that the agency has used to identify a problem and on which it bases its solution to the problem. So data quality, quality of scientific evidence. We don't second guess the scientific evidence. We just make sure that the evidence that is being used is complete, that the agency isn't selectively cherry-picking studies that happen to support its position. And we also make sure that the science it is using meets basic criteria for scientific quality, such as peer review and publication in an accepted outlet. The other thing we look at is costs and benefits of a rule. We require on all economically significant rules what's called a regulatory impact analysis. How much is this rule going to cost? Who are the costs going to fall on? And what, to the extent they are quantifiable, are the benefits of this rule? And to the extent they are not quantifiable, how would you describe the benefits that this rule will achieve? I tell you all of this to give you a picture of a very technocratic kind of process for looking at rules. It is a process of incremental balancing of regulatory alternatives. It is a process of looking deeply at the data and of making judgment calls about whether or not there's a real problem to be solved, whether or not the solution that is embedded in the regulation is likely, based on the evidence, to solve that problem, and whether or not the costs of the rule are justified. And I use that term deliberately. It is not always the case that the benefits, the quantified dollar value benefits of the rule have to be greater than the dollar value costs. Indeed, there are some statutes that require regulations that are going to be net costly for society. The agency has no choice but to promulgate those. So what we want to make sure is that the rule is no more costly than necessary. There are other rules that will have benefits that are simply not quantifiable. The Justice Department, or at least in dollar terms, the Justice Department had a very important set of rulemakings involving violence in prisons, and particularly prison rape in the federal system. There are, to be sure, quantifiable benefits that one can get out of such a rule, but there are also critical benefits about our humanity as a country, about what we view as tolerable in a civilized society, and indeed dignitary interests of any people in their quality as human beings, whether prisoners or not, that are vindicated by that rule. Those are legitimate benefits of a rule, even if not quantifiable. So we would allow an agency, if it shows that it will indeed achieve those benefits through its rule, to count those, even if the costs are quite high in dollar forms. So it's a very detailed analytic exercise that we go through. It is then very interesting to come from that perspective of working on rules and to see the rulemaking process as one that is to some extent scientific, to some extent economic, to some extent, really to many extents, very analytic and careful, to then hear rules discussed publicly in ways that are very, very different. So we will hear about a rule that we have worked on very hard, or someone may read about a rule that moves from being, well, that was a very careful, well thought out rule, to a rule that is going to be horrible for workers because it leaves the possibility of some dramatic harm. It doesn't eliminate all possible harms. Or on the other hand, a rule that is going to create costs for a certain industry and is going to shut it down and cost millions of jobs. And the rule will be painted in very broad stripes that are quite distinct from the kinds of analytic issues that the agency has thought about, indeed that stakeholders have brought to the agency, and that we as an office have analyzed. So what I want to talk about today is what I see as a shift in the political debate over regulations, what I think some of the possible consequences of that shift are, and ways that we might move forward in a way that rebalances the political debate over regulation in a positive way. So what is my evidence that there is an active political debate over regulation? I don't feel like I particularly have to marshal a lot of evidence for that, because one can read the newspaper and see a lot of discussion of regulation. But actually, if one looks over time, I think there has been an increase in the salience of regulation as a political issue. So politicians at all levels send tweets and texts and various kinds of missives over electronic media about specific rules. One sees this, or about specific regulatory agencies. One sees this rather frequently. Candidates for political office increasingly, by certain counts that I have done, whether generally or with reference to specific rules, make regulation an important part of their campaign agenda. And key constituents groups make their views on particular regulatory agendas major issues in elections, even national elections. If one goes back to the 2008 presidential race, network neutrality, a possible set of regulations, now a real rule, that the FCC was then considering, or people wanted the FCC to consider, was actually a fairly significant issue on which both candidates in that campaign articulated views and were pushed by stakeholder groups to articulate views. If one looks back at the 2012 presidential election, there were starkly different views of a particular regulatory agency, the Consumer Financial Protection Bureau, at issue in that race, with very different views being espoused by Governor Romney and by President Obama. So regulatory issues have certainly been salient in the political sphere, and I think increasingly so. I do not think that it is surprising that regulation should be part of the political debate. I also think it is a good thing in general, or in many ways, for regulation to be the topic of political debate. Rules affect people's lives in many ways, and rules are typically crafted by federal agencies with large career staffs that are at some remove from anybody who is directly elected by the populace. So if one thinks about how widespread rules are, I mentioned earlier, 3,500 rules a year, the enormous range of activity that rules touch, and you name it, there is regulation from somewhere that bears on that topic. If you're a duck hunter, you may not know it, but various aspects of the hunting season and the hunting limits are going to be affected by certain rules that the Fish and Wildlife Service puts out as a routine matter every year. If you enjoy snowmobiling on public lands, you probably have learned that the emissions requirements for snowmobiles used in national parks changed a couple of years ago. Things that don't hit the newspapers, and one can go to every aspect of life that any of us might live, and regulations touch it. So I think it is a valuable thing to have public debate over regulation. The kind of transparency and accountability that come through public debate over the reasons for a rule, over the effects of a rule, over whether or not society wants to bear the costs of a rule, or whether society believes that it is getting worthwhile benefits from a rule, are healthy things. So I have no concern with the general proposition of political debate over regulation. shedding daylight on the reasoning, evidence, assumptions, costs, and benefits behind a rule, help the public understanding of regulation, and I think increase the legitimacy of the regulatory state. A state of policymaking that, as I said, often comes from places that the public doesn't have a lot of visibility into just because of the way the institutions were set up originally by Congress and the Constitution, and by the way they've evolved over the decades and indeed centuries. There is, however, an aspect of current public debate that I think is problematic, and that I think is less healthy for the evolution of the American regulatory state and indeed the public's perceived legitimacy of the regulatory state. And I would describe that trend as a tendency towards absolutism, whether pro or con, with regard to regulation in general and particular rules and specific rules that the government may be enacting. And this absolutism is reflected in very polar views, often using inflammatory language and very selective facts about the effects of regulation or of a particular rule. I'll give you some examples. One prominent progressive advocate found that, or believed that, the flow of health and safety regulations during President Obama's first term was very slow, that the promise of a revolution of new rules that would protect all aspects of Americans' health and safety had been unrealized and predicted disasters in the second term, health and safety disasters, even if a second term were even to occur. Advocates for health and safety falsely blamed a particular death on specific people within the administration because they believed the death would have been prevented by a rule that the Department of Transportation was unable to issue on time. Now, the interesting thing about it is that death took place in 2012, and the Department of Transportation rule would have affected safety standards on vehicles built long after 2012. But there was no hesitation about using the imagery, and indeed the exact words, of blood on the hands of the officials who were not successful in getting this rule out. Meanwhile, opponents of that very same rule from the auto industry were saying that if that rule had been issued, the auto industry would have had to shut down many plants, and there would have been losses of tens of thousands of auto worker jobs. That was a similarly inaccurate statement of what the costs of the rule would have been. And those who worked on the rule, the serious advocates from both sides, both for industry and for health and safety who worked on those rules, probably did not recognize the rule that was portrayed in the public debate. Nonetheless, the public discussion of this rule became extremely polarized, and one had to choose between being either somebody who is willing to let people be killed unnecessarily, or one who is ready to kill a great American industry and leave thousands of workers without a paycheck. When the debate occurs in that polarized kind of fashion, it's very hard for the public to have any reasonable understanding of whether or not they should be for or against this rule. Because you're asked to pick polar sides, and you get very little of the transparency and the information that would help to people to make a reasonable evaluation of what this rule would do. And I think we see, as a more general matter, the increased use of parade of horribles language against numerous rules. Rules will kill jobs, or raise taxes, or doom particular industries, often before the details of a particular rule are even known, often before the rule is issued. we hear that kind of very polarized framing. Or, on the other side, we hear that the government is failing to protect Americans from dangerous toxic threats, from harms in the workplace, from threats to the environment and safety, without a lot of specificity, and this pushes towards an ideological framing. One is for or against regulation. And if one goes back to the system I described of an evidence-based, economics-based, analytic system of approaching real problems and trying to find balanced solutions to those problems, all of that stuff in the middle that is actually being done is lost. It is lost from view in the public debate, and I view that as a significant problem because regulation now becomes not a question over reasonable alternatives of how to solve real problems, but of denial of problems, either the problem to be solved or the problem of solving it through regulation. And we wind up with a battle of competing hyperbolic claims, with impending disasters for health and safety on one side, squaring off against doomsday predictions of mass job loss and threats to freedom on the other side. And lost in this discussion is the reason for regulating in the first place and of reasonable alternatives for addressing the underlying harm. So I talked before about what I think could be a good discussion, a good political debate over regulation, one that highlights the reasoning, evidence, assumptions, costs and benefits of a rule. Unfortunately, there is also the alternative that we see increasingly creeping into, I think, public discourse of a bad debate for regulation that pushes out all of those issues and pushes us more towards a very selective and inflammatory framing of the regulatory debate. So I think the public discussion of regulation today is at a tipping point. We have both these strands that are in the political debate. Some very full discussions of rules and the real problems that they are designed to solve and the real problems in solving them through regulation, but also a far more polarized debate of bad, distorting rhetoric that tells the public rather little about the policies that are being enacted. So what is at stake? Why does this tipping point matter? Isn't this just all the kind of normal noise that we would expect to happen out there in the world? And can't the regulatory process move forward? Well, my concern is that when one loses focus on the reasons that we regulate, and when one loses focus on the reasons that we also ought to be cautious about regulating, we undermine the very foundations and the underpinnings of our regulatory institutions and of the regulatory state. And we can start to push towards changes or alleged solutions to the problem of either over-regulation or under-regulation that undermine what is in fact a really enviable system of regulatory process and policy in the United States. We have a regulatory state that I think is second to none, and I do a lot of work on the international regulatory front with Canada and Mexico and the European Union and through APEC with a variety of Pacific Rim countries. One of the things we're always working on is good regulatory practices. And one of the things I am always interested to see is how our system compares in its transparency, in its public participation, and in its accountability of regulatory institutions to those institutions of other countries. And I think we are without parallel. The Administrative Procedure Act is remarkable. It is a long-standing and I think well-understood institution. When one looks at what the Administrative Procedure Act does for regulatory process, it really keeps focus and accountability for the very issues that I mentioned earlier. The quality of rulemaking, the evidence for which rules are made, the evidence that the rule will in fact achieve its objective. If one thinks about the process side of the Administrative Procedure Act, agencies have to propose a rule. That rule has to go out for public comment. Then those public comments have to be taken into account in the final rule that the agency issues, And if the agency doesn't adequately take those comments into account and goes forward with a rulemaking that doesn't look strong given the administrative record, there's judicial review and accountability for the agency. And this is used constantly. It's an active, vibrant system. It's not a theoretical possibility. If one looks at the number of rules, small and large, that are challenged in the federal courts every year, the Administrative Procedure Act really has a very strong accountability function in the American regulatory state. So when one follows the procedural requirements of the APA, one sees transparency, one sees public participation, and very importantly, accountability that means that the agencies cannot discount that public participation. These are all things that I think have been instrumental in building legitimacy for our set of regulatory institutions over the decades. When we have a political debate that ignores the fact that we have that very well-functioning system in place, and instead turns discussion of regulation into inflammatory pro and con battles, we run into a system where, as a public matter, the focus then is on the rhetorical claims that are made, and much less so on the systems of redress and accountability that are in place, and that can lead to an undermining of, I think, public confidence in the regulatory state. And when that happens, I think a natural response is to make changes to the regulatory state, whether through legislation or whether through the actions of regulators within the context of our existing institutions and our existing statutes. And those are things that would depart from, I think, the system, the process and the practices that have evolved under the Administrative Procedure Act over the decades. And I think that is problematic. The other thing that I think we lose track of when we listen to these polarized debates is why we regulate. We have a centuries, if you will, of learning in the United States about reasons we might want to regulate. We don't regulate reflexively in this country. Sometimes we regulate because Congress got together to solve a problem and mandates a particular set of actions by regulatory institutions. But very often regulatory institutions are acting under broader authority granted to them by Congress to address problems as they arise. So what are the kinds of problems and what are the theories on which we might regulate? And what are the lessons that risk being lost if we start to depart from our current set of institutions and our current ways of thinking about regulation? Well, we regulate to reduce externalities. What do I mean by externalities? Third parties can be innocent victims of market transactions. If, for example, I'm a manufacturer of a certain product, and I have developed a very cost-effective manufacturing technique, my customers may be very happy because I deliver them the products they want at in a very cost-effective way. So everybody's happy, right? But what if I use a manufacturing process that in fact creates long-term health effects for my workers? The economic transaction between the manufacturer and the buyer leaves a cost unaccounted for. The health effects on the workers who are actually making the product. And years later, as they develop those health effects, they've got to pay for them. Or, to the extent that there is an insurance system, we all pay for them by the shift that creates an insurance premium, or the public health system has to bear the costs. There is a third-party cost, if you will, to this market-based bargain between the buyer and the seller. That would be a classic example of an externality. Regulation is often used as ways to assign costs to parties when those costs will not naturally be accounted for through market transactions, what economists call the internalization of externalities. So we might tell the manufacturer, you have to start using a different process that will not impose these costs on the workers. And the manufacturer will say, That's going to make my products more expensive. It's going to be harder for me to make good profits. And the customers will say, we're going to have to pay more. That's fine. But if they don't pay more, if the profits aren't reduced and the new manufacturing technique isn't used in my hypothetical example here, we're leaving third parties to bear costs. And the typical view is that parties should bear their own costs of their actions. So we use regulations to assign those costs away from the innocent third parties, if you will, and to the main parties of the transaction. And there are different ways we can do that. But reducing externalities is a key reason for regulating as a theoretical matter. When we start to talk about regulation only in terms of its costs that it imposes on a party, or only in terms of its failure to reduce all risks, we lose track of the reason that we regulated in the first place, and the fact that what we may be doing is not creating new costs for a set of parties, but repatriating costs that they themselves have created. That's not always the case, but if we don't have a meaningful discussion of regulation, we can get a very distorted and inaccurate discussion of regulatory costs. What about provision of public goods? There are often goods that are created that you can't exclude somebody from. So somebody produces those goods, but nobody will pay for them because without those goods being paid for, why would anybody produce them? And why would I pay if someone else pays? I can't be excluded from them. Key examples of a public good are often considered national defense. Now, public good we tend not to regulate, we tend to provide as a government. But sometimes we also have to put in place various property rights or regulatory regimes to bar access to non-payors. That's regulation that makes things more costly for a certain set of stakeholders, but on the other hand, may do good things for incentivizing production in society. And so there have been movements at various times to allow people to take goods that are produced and to put them out publicly for anyone to use. Often it's third parties wanting to take goods that have been produced by somebody and to display them publicly. We have an intellectual property regime so that which is a form of regulation in order to do away with those disincentives which would harm the provision of public goods. Why else do we regulate? To protect consumers from information asymmetries. Very often, those who produce goods know an awful lot, or produce services, know an awful lot more than the consumers who are buying them. So we want disclosure of information to consumers about what the actual health effects will be so that they can actually make informed market-based decisions. So you'll often hear people say, we don't need regulation. Let markets solve the problem. People can make their own decisions. That's fine if people are getting adequate information to make those decisions. And very often the information is not publicly accessible, or is accessible only after very long periods of time during which certain effects will have built up. But that information can be in the hands of the producer. Regulations that require such disclosure are often criticized for driving up costs. It costs money to disclose information, reducing sales and production, and the focus will be on the harm that those disclosures create to industry, and they'll often frame the debate in terms of letting people have free choice. But how do you have free choice if you don't have all of the information you need to make such choices? So if an industry, for example, hides information about health effects, information that it has, regulation is a very useful way to force the industry to disclose that so that we get more informed and better market transactions, not an interference with market transactions. So consumer protection and information asymmetries are another reason for regulating. And finally, the most traditional reason for regulating, and probably the one nearest and dearest to my heart from a lot of work that I've done, is to prevent the exercise of monopoly power. I'm not talking so much about economic regulation today, But certainly we have often put in place various kinds of regulatory regimes to limit the ability of monopolists to extract rents from consumers. In English, charge them super high prices that don't bear any relationship to the costs of providing the product. So there are often very good reasons for regulating. If one looks at a lot of the biggest regulatory debates that have occurred recently, you'll notice that what you often hear from a proponent of a regulation, so there's an advocate for a regulation that isn't happy that that doesn't think the rule goes far enough, you'll rarely hear a nuanced discussion of the problem to be solved and of whether or not regulation will solve the problem. You'll hear talk about malfeasance in refusing to deal with the problem through regulation. And if one hears from the other side, from the opponents of regulation, what one often hears about very narrowly are the effects that this rule will have on the costs of that firm or that industry. And then, with some kind of leap of faith, on the effect that the regulation will have on the jobs, for example, in that industry. And it's a very narrow lens that is completely divorced from any of the reasons that I just articulated for why we might be regulating in the first place. If the public is only hearing those polar views, how can it make a decision about whether the rule is necessary? What you get, even from some very, from people who read and try to understand the rule, is a sense that there was never any reason to go forward with this rule. It makes no sense. Or, why wouldn't the government go forward with this rule? There must be some political reason that they're refusing to do so, rather than any of the sort of analytic reasons. Now, I just went through some of the reasons that we do regulate, and some of the reasons that we might want people to think about, what we've learned from history, from economics, from experience about why we might want to regulate. We've also learned a lot about why we don't want to regulate, and why regulation is highly imperfect. So, for example, we know a lot now about how firms will use regulation to their advantage and actually seek regulation that might protect their place in the marketplace. So the great George Stigler from the University of Chicago did seminal work in the 1960s about how firms might use regulation to seek rents. And so you get regulatory capture, if you will, of an industry getting a little too cozy with the regulators, and the regulators, instead of protecting the public, or in addition to somewhat protecting the public, are actually protecting a particular set of firms in the marketplace with some potential harm down the road. We also learned that when we have a model of regulation, so the process that I described of a rule coming in, of being analyzed based on its evidence, of a lot of scientific and economic input into the making of the rule, well, you can't see all things and all possible effects when you develop a regulation. The result is that there are often unintended consequences of regulation. One could have a rule that is made to look terrific. We are going to avoid all train accidents by reducing train speeds within 50 miles of an urban area and in an urban area to less than 40 miles per hour. That's a hypothetical rule. I'll throw it out there. That sounds great. When trains don't go rocketing through these urban areas, maybe we will get some reduction in the number of accidents that occur as trains go through more populated areas. Okay, so safety advocate might say, why wouldn't we do such a rule? We can see that there are accidents that occur at faster speeds than that in urban areas. We want to prevent those. Let's stop them. Well, there's an unintended consequence to that rule. Then this is purely hypothetical. The unintended consequence is that as all those trains slow down as they come within 50 miles of an urban area, that slowdown ripples back out through the network. So suddenly, the safety advocate goes shopping and says, but wait, there is no bread at my store. There is no poultry in the poultry aisle. The shipments aren't coming in. You have to look carefully at what all the consequences of the rule might be. And what we have learned is there are often unforeseen or unintended consequences from regulation. So we've learned to be somewhat modest by regulating when we regulate in the face of such uncertainty or in complex systems. Because often the harms that we create are worse than or not often, but on occasion, the harms that we create can be worse than the harms that we are trying to avoid. What else have we learned? Well, sometimes regulatory standards short-circuit superior developments that would have occurred through technological innovation or through the market. So when you put in place a rigid technological standard, all the firms might go ahead and meet that standard. But because that's the regulatory standard, why would you spend money to do better or to do more? And so you can have regulation supplanting all of the diffuse innovation and market events that are happening out there in the world. And that too can be a sort of bad path that is created by regulation. So what we discover when we regulate, and if I went into, there are many difficulties, for example, with getting accurate information and data quality for regulation. So what the decades have taught us, if they've taught us that there are a lot of good reasons to regulate, they've also told us there are a lot of hazards in regulation. When you take these things together, we have a regulatory system in the United States that has developed to be somewhat evidence-based, quite rigorous, more modest than one sees in a lot of other places. And if I were to highlight the difference in sort of a single term, I would say we have a relatively risk-based and evidence-based regulatory system, whereas other jurisdictions, and I would note the European Union, where it's very explicitly precautionary. They tolerate much less risk. So if there is some evidence that a rule might, let's say that some chemical or some practice is harmful, they are likely to adopt quite a strong regulation against that practice with less concern for whether they're really stopping a harm and for less concern for the possible consequences. We in the United States want a more rigorous assessment of whether the solution is really going to prevent harms and a more rigorous assessment of what the costs will be. I think that the Administrative Procedure Act and the way that our regulatory system has developed, and when I talk about the APA, I also mean the set of judicial doctrines that has grown up around the APA. I think when we take those together, we see a system that is a little bit hard to get a grasp on from the outside because there is lots of technical expertise that goes into rulemaking. And so in some sense, we have a regulatory system that hinges on public trust and faith in the institutions that issue rules, and public trust and faith in the institutions that hold regulatory agencies accountable, and that is to say, for the most part, the courts. I fear that a completely polarized debate over regulation that doesn't pay attention to any things that I have talked about actually can undermine confidence or lead people to ignore these very high-quality institutions that have developed over time. Now, to be sure, there are some regulatory agencies that are less good than others. And there are some court decisions that come out, with all respect to members of the judiciary in the room, that might sometimes be hard to comprehend. But I think if one looks at the system as a whole, it's a pretty well-functioning system. There have been rules that have sparked public outcry. What's interesting is how many of those rules have met their match in the judicial system. Quite apart from my views of any of those individual decisions, as a system, what we are showing is that our system of regulatory accountability is a strong one. What I worry about is if we have a debate that that is inaccurate, that focuses selectively on very limited facts, and that adopts hyperbole about the consequences of regulating or not regulating, the political pressure that mounts is political pressure to alter how those institutions function. And depending on what the political cycle is or the political mood is over a period of time, that could be a political mood that leads to fewer constraints on regulation and a lower degree of accountability for regulatory agencies, and therefore too much regulation, losing the lessons of the past of what the hazards of regulation and the limits of regulation are. Or, on the flip side, too many constraints and limits on regulation, such that we have real hazards that grow and develop over time, and they're not caught until the harm is done. And there is real example that one can find of success stories in our regulatory system. People point to the rules that were bad rules. They point to rules that didn't make sense or that over time were seen to be less good rules, or rules that were overturned by courts and sent back to the agencies because they were poorly done. Well, to me, that's the system working. There's a big risk if we put too many constraints on the system and it doesn't work. Think about, if you will, the story of thalidomide. Thalidomide was a drug that had some real valuable uses in the late 50s, early 60s. It had been approved in Europe and in 20 other jurisdictions that had approval regimes. And it came to the Food and Drug Administration for approval. And there was extremely strong industry pressure to approve the drug. And indeed, there'd been all this work done by these other jurisdictions, and so a number of folks at the FDA were perfectly content to rely on the work that had been done, didn't want to pick this big fight, and were going to approve the drug. It was one person in the FDA, one of the 6 or 7 physician scientists who were assigned to work on the thalidomide process. Her name was Frances Oldham Kelsey. And she said, I'm looking at the data, and the data tell me there's a problem here. This is potentially extremely dangerous, and we need to watch out for this. And because we had a system of public accountability, the higher-ups at the agency had to pay attention to what she was saying because they had to worry about something very concrete, a challenge to their decision to approve the drug that would expose the record that was used inside the agency to review the drug. And this data that Dr. Kelsey identified would have been in that record and would have been in the public judicial record. So the FDA banned the drug, and history shows that they were very right to do so. I think if you had a system where that kind of technocratic analysis was less present and less salient, and we had less faith at the agency that the accountability system was going to work, and less faith by the public in how the agency was working, we might have had quite a higher level of harm from the use of thalidomide than had already developed. So I think that there is a real potential cost to political responses that would alter our current regulatory system in a way that is either too lax or too unconstrained. So let me come back to what I think are some of the hallmarks of our regulatory state today, some of the directions that I see it being pushed, and how we might pull back to a debate that I think is a little bit more healthy going forward. I think we have today a system where Congress has to deal with so many issues in a very tight, highly divided political environment. This isn't news, and it's been the case for decades, just to different degrees. The result is that Congress passes broad statutes and increasingly devolves the authority to make the specific policies, that is the regulations, to regulatory agencies. So these regulatory agencies, whether they're executive branch agencies or independent agencies, are in some ways creatures of Congress, and a recognition that Congress has a certain level of capability, but pushing the granular policymaking to expert agencies can have some real benefits. And the APA and the system of judicial doctrines for review of regulation that have grown up out of the APA recognize, again, with certain limits, this kind of agency expertise. And through the budgeting process, the agencies have been able to build up their capacity, not perhaps ideally, not in all agencies the way I would like them to do so, to do the very technical kinds of analyses that are required to make good rules. Rules that will then have to go through review in my office if they're significant rules, but whether my office exists or not, that will have to go through the public notice and comment period, and then the system of accountability provided through judicial review. It seems to me harder to do better than that system in a big and complex democratic society. Does that mean that there can't be adjustments, tweaks, refinements? Of course there can be. There are always ways to improve a system. And I think a healthy political debate will push us towards ways to improve the system. But I worry about a debate that will lead to a seesawing over time of policy. In certain periods, we might see lots of legislation that backs up over the accomplishments of the Administrative Procedure Act and puts in place many, many more hurdles for regulation that will in fact prevent society, American society, from acting to solve the harms that a century of learning have taught us are the harms that regulation should address. On the other hand, in a different political mood or a different political cycle, we might see more statutes that actually prevent agencies from taking into account certain kinds of costs of regulation. And there are some statutes that actually say the agency must regulate under certain circumstances and the costs don't matter. There are a few, but they are there. If we had more of those, we would lose the other set of learning about why we should be modest and approach regulation with caution and some humility. We've struck a great balance. And I think the consequences of the polarized and increasingly inflammatory political debate are a risk of losing that balance. So the last thing I want to talk about is how we might pull the political debate back to one that is healthy and has less of the unhealthy aspect. So let me start by saying I'm not naive. People on both sides of the regulatory debate are going to continue to use inflammatory language. So one can always make an appeal that other more responsible folks step into the fray and make more nuanced, more moderate, more fact-based and analytical arguments to the public. There are people who try that, but that's sort of a hard appeal to make. So we can always start by making that appeal, but let's be real. We need some slightly different, more concrete steps, I think, if we're going to avoid some of the possible hazards that I've identified. So I think we need to start first with why the regulatory debate is naturally oppositional. When one regulates, one creates costs and one creates benefits. But there are big differences in how salient the costs and benefits are. Costs typically have the characteristic of falling on a fairly defined group of people, being relatively certain and relatively short-term. So you've got a very organized and focused group of people ready to complain about the costs. What about the benefits? Benefits tend to be longer-term. They tend to be diffuse, spread over unorganized groups of stakeholders, and they tend to be speculative. If I tell you that a firm has to spend $1 million today to prevent the likelihood of disease amongst its workers 30 years from now, who's going to complain more loudly if we have or don't have the regulation? Business is going to complain loudly because they can see the costs today. Workers might complain less loudly if there's no rule, because first of all, we all tend to think we're not going to be the ones who get unlucky. And we all tend to discount today how unhappy we are going to be about having that harmful consequence in the future. That is to say, our willingness to pay today to avoid illness 30 years from now is probably artificially low due to certain things we know about how people think and cognitive psychology. So we tend to have this focus on costs and not on benefits. So I think we can do more as a government to talk concretely about the benefits that a rule will achieve and the underlying evidence for those benefits. And that's one way to try to balance the debate publicly. But I think there are two other very concrete things government can do. I think government can be clearer about what it is taking into account when it regulates. So one of the things that my office always focuses on is the explanatory language that accompanies a rule, the preamble. The more that is in there about the balances that the agency has taken into account, and the more facts and figures that underlie that balance, I think the more likely people will be to accept that regulation has been well wrought. So I think better efforts to be explanatory in clear language for the public about what has gone into rulemaking can help. I think another thing that can help is increased focus publicly and more of an effort by the government to convince people that we will continue to look at rules even after they have been passed to make sure that they are achieving their benefits, that they are not unexpectedly costly, and that we are not getting unintended consequences. So a retrospective review of regulation is something we can do more of as a government. And I think that that is another aspect that can help to strengthen faith in American regulatory institutions. President Obama, a few years ago, released an executive order 13610, that mandated that agencies do more retrospective review. Since 2012, we have had agencies twice a year file with my office, and it's mandatory that they file these, retrospective review plans. Those plans to date have led to modification or repeal of rules with 5-year savings of $38 billion to the American economy. We've now institutionalized this process. I think it was one of the missing pieces, and I think that people will be less, I think there is the possibility that the debate over new rules can become less fraught if there is confidence going forward that there will be continued monitoring and attention of how those rules are actually operating over time. So the retrospective review and stewardship of rules already on the book, not we wrote that one, let's move on to the new one, but we wrote that one, let's come back and make sure it's really working, will help to strengthen the legitimacy of regulatory institutions in the face of the polarized debate. And the final thing I want to mention is I think we can modernize the public participation part of regulation. And I think if we do this, we cut out the information intermediaries that are doing a lot to inflame and polarize debates over regulation. If we actually made it easier for individuals to see what rules were coming out, what was at stake, to comment on those rules, and to understand how those rules are likely to affect them, people might have a more direct source of information that they could test and discuss. So modernizing our regulatory system so that we take advantage of digital technology to be more direct and participatory, I think is a very promising avenue. And I think the first steps are coming here. I think that there are tools out there, machine learning tools, other kinds of search tools that are very sophisticated, that allow people to participate more easily in regulations. There will be a market, and we're starting to see these, of apps or of computer programs that will inform people when a regulation that affects something they do is coming out of government, and will immediately take them to a place where they can read about the rule, see the costs and benefits as articulated by the agency, and comment on the rule. I think that kind of direct participation, the use of digital tools to modernize regulation, is a worthwhile investment. Might be something of a moonshot right now, but I think it's going to happen fairly quickly over the next decade. That way, bad information being created by partisan intermediaries gets pushed to the side, and direct information is more accessible. So retrospective review, regulatory modernization, and continued efforts by the federal government to better draft and explain its rules can help to right our regulatory debate and preserve what I think are the key lessons of the past, both for and against regulation, and the strength of the American regulatory state, which, as I said, from what I've been able to see and study and experience, is unparalleled. Thank you.
So we're going to have a reception in the Zilber Forum. Mr. Shelanski, being a law professor, is eager to answer questions, but we're going to do it in that format. I will not deny that Mr. Shelanski, also being a political appointee, may dodge a question or two, but that will be between him and his particular interlocutor at that moment. The other thing that I want to say is a warm thank you to Howard Shelanski for coming to us from Washington, D.C. and the White House and giving us a sense of not just regulation as it has stood for a long time. The only mild disappointment is that I did not hear a specific reference to the Interstate Commerce Commission, but we'll work on that for the written paper, and more importantly, giving us a sense of how it's playing out today. I know the ICC was eliminated a few years ago, and how it's going to play out in the future. So, Howard, many thanks.
Thanks, Joe.